I want now to ask you from a U.S. standpoint as an attorney at Wachtell, Lipton, that often represents companies doing both transactions and defense. Kobe had mentioned the fact that there is some level of shareholder activism that targets controlled companies in the U.S. What's your experience? To what extent this is a concern for companies that have controlling shareholders, or for companies that have controlling shareholders, are there specific circumstances like doing significant transactions?
What I would say is that in the U.S., obviously most of the activism occurs at companies that don't have controlling shareholders. As far as companies that do have controlling shareholders, when they are underperforming, several different things can happen. One is that you can obviously raise issues with the management, try to get some type of representation. But what normally is focused on is trying to eliminate the dual class capitalization when that's real, when there's a real concern. And that is obviously an uphill battle. There's often litigation that's involved there. It's a multi-year process, and many activists just aren't willing to really line up and push for the multiple years of pressure that would be necessary.
That's what one clarifying comment. Eliminating dual class means that's what Kobe would call against all odds, right? You have no formal legal right, but nevertheless you try to push the company, the controllers, giving away their control, right?
Yes, it's not, in these types of companies, there's no sunset provision, there's no automatic, passing the generations or something. In some companies there are, but in most companies there are not. So where you see activism in these situations tends to be transaction-oriented, when they are attempting to do a transaction or create a new set of securities or do something that impinges on the non-controlling shareholders, with either as a matter of statute or as a matter of often the company's bylaws or charter itself. There are specific rights provided that only these actions be taken with the approval of a majority of the minority or a certain percentage of the shareholders. When that's the case, they have the so-called foot in the door that Kobe was talking about, because while they don't have a formal veto right, if an activist accumulates a sufficient stake, or working with other institutional holders, which they can do, they can make their views known and create a blocking position that will not allow the transaction to proceed.
Are they allowed to coordinate?
They are allowed to have discussions.
What's discussion and coordination?
Well,
the fine line.
The trigger in the United States is if you have more than 5% of the shares entering into some type of agreement. It doesn't need to be a written agreement, it can be an oral agreement. Then you have a reporting obligation. But simply having discussions and seeing whether somebody might support a position or would have interest in supporting a position does not trigger that reporting obligation. In addition, there are specific mechanisms in the United States that allow an institutional holder to let its views be known broadly without triggering any of these obligations. So, for example, in a proxy contest, a shareholder who might have, an institutional shareholder with 8% may file a press release or another document saying that we oppose the position that management's taking. It doesn't create any different obligation, but it's telling the rest of the world that its position is out there. And we're seeing that more. It's not a predominant process, but where we see this the most, best example is something in the U.S. called appraisal rights. And appraisal rights are a situation where, when a transaction occurs that does not involve, with some exceptions, you're allowed to petition a court to find the fair value of the transaction. And the big issue for an acquirer is it creates uncertainty, because the acquirer doesn't know what value it's ultimately going to have to pay at the end of the day. So what happens with appraisal rights is is often an acquirer will put a minimum condition, or this was the idea, they put a minimum condition saying that, you know, if there's less than 5% appraisal rights, then I have to proceed. But if more than 5% of the shares, you know, elect appraisal, then I don't have to go forward with the transaction. And what they didn't realize was they were putting a loaded gun in some activist hands, because obviously the acquirer has made many investments, investment of time, investment of resources, and it wants to complete the transaction. So if an activist comes in and gets 6%, yes, the acquirer has the threat of walking away, but the more normal sense is that the acquirer will try to find a price or an opportunity to see if it can either it'll threaten to waive, but at the same time it'll see if it can bring along that shareholder by either increasing the price or changing some of the terms of the security or something along those lines. And activists have frankly been pretty successful. We call this deal activism in a number of different circumstances. We've also seen that happen in Europe to a large degree because of the significant minority rights that exist in the context of a transaction. And I would expect in Israel that to the extent that minorities have that right, that presents an opportunity for an activist to
In debt to equity, we do it as institutional investors.
So I'll